You may not know it, but attorneys' firms are accountable institutions in terms of the Financial Intelligence Center Act. It means that they have obligations to the government against their clients when it comes to the financing of terrorism and when it comes to money laundering. An attorney does have a duty of confidentiality to their clients, but it is a legal duty in terms of the law of the country. Unfortunately, that legal duty is somewhat restrained in relation to legislation such as the FICA or Financial Intelligence Center Act. This is for good reason, in a sense, because attorneys act much like financial institutions. Because they can only take money for work which they have already done, attorneys always make extensive use of something called a trust account when it comes to certain large transactions in the very least. And while some attorneys don't really use their trust accounts, it's often a risky thing not to. And in order to practice as an attorney must have a trust account by law. A trust account is essentially an account with a bank where they keep other people's money and they keep extensive financial records of what is going on with other people's money in terms of the law. So an attorney in a sense acts a bit like a bank when it comes to their own clients, and money can go into trust accounts when the clients won a case, or it can go into the trust account from the client themselves to pay for services which have yet to have the work involved with them be done. It is also often used for transactions such as conveyancing transactions and so forth. So a trust account is a very important part of an attorney's firm, and attorneys are therefore accountable institutions in terms of the legislation. Now, the legislation for money laundering is a lot more complex than you might originally think. When I was researching it for my own firm's compliance, I spent hour upon hour upon hour reading reams and reams of legislation and regulations to try and figure out exactly what I needed, and also various bits of literature on the law itself. I eventually established quite an extensive intake form for the Financial Intelligence Center Act, and a lot of the information you need for the Act I also cover as vital basic information that an attorney should be collecting from their clients in any case. FICA requires that an accounting institution cannot open a business relationship with someone until they have been verified in terms of the FICA legislation, which means that until the actual verification of a person's identity takes place and various parts of that identity and the relationship between the attorney and their client, the client is not yet a client of the attorney. This also means that attorneys should not be charging their clients for the time in which they are doing Financial Intelligence Center verification. I'm going to go through some of the questions and fields, in a sense, that I identified for my own firm's purposes for dealing with individuals and some of the corporate or non-individual entities which exist. I'm not going to go through all forms of entities, only the main ones. Okay, so questions in terms of compliance, money laundering, know your client requirements, and you need to, if you're a firm, also create your own sort of requirements, and if you're an ordinary person, it's useful to know exactly what's going on with FICA. The banks are also bound by the same sort of regulations, and if you're interested, go onto the website of a bank and look for their FICA compliance documentation stating what exactly they do with FICA. They don't always follow a process I deem correct depending on the bank, but they do give you an idea of exactly what they're doing, and it's very complex what actually is correct, and you often find debates among accountable institutions as to who is actually complying and whether or not they are complying, because it's quite complex and there's a lot of vagueness involved quite often. So has the identity of the client been established, and how? Now, this is something which we're going to go through a bit further down, and a lot of these questions which I'm going to ask at the start are actually questions which you'll know the answers to a bit later, but I had them early on in my own form because I like to have them at hand if I want to open up and see what I'm looking at. Is the client acting on behalf of another person? If so, who? This is quite important, as someone might be approaching an attorney in their own regard or in regard of someone else. And in addition to this, attorneys are not allowed to deal with touts, which are people who deal with other people's matters and are not in fact authorized by that person to deal with it. And it can cause quite a bit of trouble because people can fraudulently sue on behalf of someone else. So it's very important for an attorney to establish the identity of someone, and it's also important for money laundering purposes and the anti-terrorism purposes, which are also incumbent in the Act. Does the client have authority to establish this business relationship or do this transaction with the firm? How is this known to the firm? Has it been established? Is another person acting on behalf of the client? What is that person's identity and how has this been established? Has a person's authority to act on behalf of the client been established and verified? How has it been established? If need be, notes, documents, etc., such as a power of attorney, mandate, resolution, duly executed by authorized signatories, a court order, letters from the master, or other documentation which I will get into a bit later, which can be specifically required for different types of legal person, or in fact, in some cases, a entity which is not a legal person. How have the above identities been established? What documents or copies of documents have been obtained to verify a person's identity as above? And the name of the person who obtained and established the above details about the client. These are actually set out in accordance with the statutory regulatory requirements. So it's actually important to get these sort of details. Then I note in my own firm's form, records should be kept in the case of cash transactions of the amount involved and currency in which it was denominated, the date on which the transaction was concluded, business correspondence, and the parties to that transaction, accounts involved in the transaction, the nature of each transaction, and where account facilities are provided to clients, the identifying particulars of all accounts, and the account files that are related to the transaction. Transactions over the determined amount must be reported to the applicable government body, regardless of whether suspicious or not. The amount is 24,999 Rand, so anything 25,000 Rand or over, whether in an individual transaction or in multiple transactions in a day, must be reported to the Financial Intelligence Center. Every attorney has to open up an account with them, and they have to submit a report of the transaction, and they also have to submit reports of suspicious transactions, which are transactions which don't fit the patterns, which will be dealt with a bit further on. The suspicious transactions can be any number of things, and it's not very clearly defined. Firms have to sort of define it for themselves quite often, though there is some guidance as to these things. And the amount above which reporting is compulsory is generally speaking for cash deposits into the attorney's accounts. It does not seem to apply to credit card transactions or to transactions involving an electronic funds transfer, where in any case the authorities would have the details. Okay, so client and law firm further compliance. What is the nature of the business relationship concerned between the client and the firm? Well, you're looking into the attorney-client relationship and into defining it without breaking confidentiality too much. So it's the sort of basics of it. What is the intended purpose of the business relationship concerned? Again, you putting some information into there about exactly what's happening. Bear in mind that these documents get kept by the attorney. They don't get submitted to the Financial Intelligence Center. They get kept in storage by the attorney safely for dealing with the client, and they have to keep these documents for a certain amount of years. What is the source of funds which the prospective client expects to use in concluding transactions in the course of the business relationship concerned, including in the current transaction? What are the background and purpose of all complex, unusual, large transactions and patterns of transactions, i.e., what is the business or lawful purpose for such? And if something contradicts this without some sort of explanation, then it will likely need to be reported as a suspect transaction to the Financial Intelligence Center. Establishing identities and recommended documentary proof to do so for natural persons, for human beings that is. And we're dealing with the client or other applicable persons forming part of the client or client business, etc. Information required in documentary proof. Some of these should have been filled out in your intake form in any case, as I set out in my presentation on basic vital information an attorney should be collecting from their clients. When dealing with multiple persons, number each and fill in the corresponding number before the details. This is just the way I do it. In the proof column, say type of proof, and if established by someone other than the main person establishing identity, say who did so. Okay, so I have full names as per identity documentation, date of birth, ID or passport number, and if a foreigner, the nationality. Okay, so proof of identity document, you see the original and keep the copy. In the case of a foreigner without a South African identity document, their foreign passport. If a South African's identity document is unavailable, then South African passport and driver's license is allowable, or an alternative document containing the person's photograph, full names or initials, and surname, date of birth, and identity number. Now, sometimes the Financial Intelligence Center allows for electronic FICAing, in which case you're not dealing with an original document but with a scan. Income tax registration number, if applicable. Now, the proof would be, and according to Butterworth's forms and precedents, they said that an IRP 5 would be acceptable. Otherwise, a SARS tax return or other documentation from SARS would be acceptable. What I always say is, I need something which SARS has given you, and then I'll deal with that. Interestingly enough, some of the credit bureaus now give the function of being able to check someone's tax number with SARS itself, and that could be something which is useful. And they obviously also have functions to check someone's identity number, though the essential thing is to get actual documents if possible and to look at the original documents involved. Okay, then residential address proof would be in the form of an IRP 5, SARS tax return, copy of a utility bill, not older than 3 months. That's the industry standard of not older than 3 months, but it depends on the firm itself. Municipal rates and taxes, mortgage statements of not older than 3 months, telecom account, short-term or long-term insurance, lease or rental agreement, site visits, etc., including where recent enough and where name and address are reflected. Motor vehicle license documentation, TV license, telephone or cellular account, mortgage statement from a bank, bank statement, account statement by retail store, or where none of the above are available, an affidavit by a cohabiting person or employer of the person mentioning name, residential address, and identity numbers of the person and opponent, their relationship to one another, confirmation of that person's residential address. Now, these are just some of the things which I list as acceptable means of proof of address. There might be other acceptable means other than that which you might be able to collect. Contact details, you don't need to have proof of these as an accounting institution, but you do need to request them. And that's the person's postal address, their telephone number, their cell phone number, their fax, and their email. Okay, in the case of a prominent or influential person or official, if dealing with a firm, this may become applicable further down. Follow the same process as above for natural persons, and in the case of multiple such persons, possibly use the number assigned to the natural person in the natural person identification. Such persons include, these are prominent or influential persons or officials. That's heads of state or government, cabinet ministers, influential figures in nationalized industries and government administration, top judges, top party officials, influential officials, functionaries and military leaders, important persons in international and supranational organizations, ruling and royal families, and top figures in religious organizations with political clout. Now, has the firm determined that the prospective client or beneficial owner of the prospective client is a foreign or domestic public official? Which? Has the firm determined that a close associate or immediate family member, including a spouse, civil or life partner, previous spouse, former civil partner, ex-life partner, child, stepchild, spouse of a child, or stepchild, civil or life partner of a child or a stepchild, parent, sibling, step-sibling, spouse, or civil or life partner of a step-sibling of the client or the beneficial owner of the client is a foreign or domestic prominent public official. Has senior management approval been given within the firm to enter into the business relationship with a prominent person, a relative or close connection? What reasonable steps have been taken to establish the source of the wealth and funds of the prominent person, their relative or close connection? What enhanced ongoing monitoring of the business relationship will take place in relation to the prominent person, their relative or close connection? For legal persons, trusts and partnerships, also possibly fill this page out in the case of a sole proprietorship, etc., where deemed necessary. What is the nature of the client's business or company? What is the ownership and control structure of the client? Okay, and then for legal person, trusts and partnerships, we're going to look into specific questions for each of the three above forms in a bit. Okay, so if the client is a legal person, beneficial ownership, what is the identity of each natural person who independently or together with another person has a controlling interest in the client? If there is doubt whether a natural person is the beneficial owner or if no natural person has a controlling ownership interest, who are the natural person to exercise control of that legal person through other means? If this cannot be established, then what is the identity of each natural person who exercises control over the management of the legal person, including in his or her capacity as executive officer, non-executive director, independent non-executive director, director or manager? What reasonable steps have been taken to verify the identity of the client's beneficial owner so as to satisfactorily identify who its beneficial owner is? By the way, manager seems to have the sense of someone who is the person who is a managing director or someone who's in control. It's not necessarily anyone with the title of manager within a firm. So you might not necessarily need to view it in the same sense as you'd view it in classical language. Okay, for a South African company, here are some additional and specific recommended verification processes. Information required and documentary proof. Some of these should have been filled out above. Is the client a principal or agent? Are they acting for their self or another? And what is their authority to act? By the way, I've based my various parts of this form on the legislation, on the recommendations of the Financial Intelligence Center, and on the regulations of the Financial Intelligence Center Act. And also, I found some useful literature in Battery's forms and precedents, which I also found of use in this regard. And I also read through what various banks were requesting of their clients to give me some idea of what's going on with these sort of things. Okay, is the client a principal or agent? Are they acting for themselves or another? What is their authority to act? what is the registered name and registration of the company, what proof, that's registration certificate, notice of incorporation, and memorandum of incorporation would provide proof. VAT registration number, income tax registration number. For both, you'd have proof from a SARS tax return. The trading name of the firm, its operating address. If multiple, list its head office and client office. Proof, IRP 5, SARS tax return, copy of utility bill, 3 months old or less, that's industry standard being mentioned there. Municipal rates and taxes, telecom accounts, 3 months old or less, again we're talking about industry standard. Or a site visit. A site visit is if you actually visit the property as an attorney or have one of your staff visit it to confirm it. The registered office, for that you have a registration certificate, contact details, post, telephone, cell phone, fax, email, then the full names of all managers, i.e. CEO, etc., and authorized representatives. Full names of shareholders with a 25% or more interest. Proof, extract of shareholders register. Do a natural persons verification as above for each. Okay, foreign companies, additional and specific recommended verification processes. Information required and documentary proof. Some of these should have been filled out above. Is the client a principal or agent? Are they acting for themselves or another? What is their authority to act? Registered name and registered number, address of incorporation, proof, registered name, etc., official document issued in the country of incorporation, and memorandum of articles. VAT registration number, proof, South African Revenue Service, SARS, tax return, if applicable. Trade name in South Africa, trade name in country of incorporation, operating address, South Africa multiple, then office of client. Proof, SARS tax return, copy of utility bill, 3 months old or less. Municipal rates and taxes, telecom account 3 months old or less, or site visit. Operating address in country of incorporation, head office of multiple. Contact details, postal address, telephone, cell phone, fax, email. Full names of all managers, for example CEO, etc., and all authorized representatives. Full names of stakeholders with at least 25% shareholding, along with the percentage of their voting rights. Do a natural persons verification as above for each. Closed corporations. I always used to think it was closed corporations, but it's closed corporations. Additional and specific recommended verification processes. Information required and documentary proof. Some of these should have been filled out above. Is the client a principal or agent? Are they acting for themselves or another? What is their authority to act? Registered name and registered number, proof, CK1 and CK2 if applicable. VAT registered number, VAT registration number, income tax registration number. Proof for these would be SARS, tax return, etc. Trading name of the company. Then proof you get for all of the applicable things involved there is site visits, IRP 5, SARS tax return, copy of utility bill, municipal rates and taxes, telecom account, 3 months or less, and so forth for these sort of things such as your trade name. Sorry, not for all of the above, it's for trade name. Business address, if more than a single address, then the head office and client office. Proof, site visits, IRP 5, SARS tax return, copy of utility bill, 3 months old or less, municipal rates and taxes, telecom account, 3 months old or less. Registered address, proof for that is your CK1 and CK2 if applicable. Contact details, postal address, telephone, cell phone, fax, email. Full names of all members, managers, CEO, types, etc., and authorized personnel. Your managers are the CEO, types, etc. Do a natural persons verification as above for each. And with your South African company, each and every single individual should also have been mentioned, which given a natural person verification for each, and the same goes for a foreign company. So each of these people you're mentioning, you need to do a verification as you did for a natural person above, which is quite an extensive thing to need to do. In the case of a partnership, what is the identifying name of the partnership, if applicable? What steps have been taken to verify this? What is the identity of every partner, including every member of a partnership in commandite, an anonymous partnership, or any similar partnership? What is the identity of the person who exercises control over the partnership? What is the identity of each natural person who purports to be authorized to enter into a single transaction or establish a business relationship with the accountable institution on behalf of the partnership? What steps have been taken to verify the partners' identities? Are the identities of the partners now known? Partnership additional and specific recommended verification processes. Information required and documentary proofs. Some of these should have been filled out above. Is client a principal or agent? Are they acting for themselves or another? What is their authority to act? What is the name of the partnership? Proof, partnership agreement and partnership resolution. VAT registration number, proof, SARS tax return, trading name, address, if multiple, head office and client office, proof IRP 5, SARS tax return, copy of utility bill 3 months old or less, municipal rates and taxes, telecom account 3 months old or less, site visits, full names of the partners, full names of executive and authorized representatives, and then you need a natural person's verification, as mentioned quite near the beginning, for each. In the case of a trust, what is the identifying name and number of the trust, if applicable? What is the address of the Master of the High Court where the trust is registered, if applicable? What is the identity of the founder of the trust? What are the identities of the trustees? What are the identities of the natural persons who purport to be authorized to enter into a single transaction or establish a business relationship with a firm on behalf of the trust? What is the identity of each beneficiary referred to by name in the trust deed or other founding instruments in terms of which the trust is created? What steps have been taken to verify the above details? Where beneficiaries are not referred to by name in the trust deed or other founding instruments in terms of which the trust deed is created, what are the particulars of how beneficiaries of the trust are determined? What reasonable steps have been taken to verify this? Trust additional, specific and recommended verification processes. Information required and documentary proof. Some of these should have been filled out above. Is the client a principal or agent? Are they acting for themselves or another? What is their authority to act? Trustee's resolution authorizing them to act must be used as proof of it. Name of trust, trust number, master's office where registered, proof trust deed and letters of authority, death certificate in case of testator. Income tax registration number, proof SARS tax return, contact details, postal address, telephone, cell, fax, email. Full names of all founders and the testator, full names of trustees, full names of beneficiaries per trust deed, and then you need a natural person's verification as above for each of these. There are other types of institutions which exist, and they would each have their own form of verification for the purposes of the Know Your Client requirements of the Financial Intelligence Center Act. I hope that this very basic look into some of the requirements has been helpful. Thank you. My name is Marc Evan Aupiais, and nothing in this presentation constitutes legal advice, and nothing that's in this presentation should be relied upon as legal advice. For that, please make an appointment with your attorney and brief them on all of the nuances of your particular matter.